Hello everybody, Gideon Joubert from PSIRA here, and today I'm wearing my South African Gunowners Association hat. I'm going to talk to you very quickly, or at least attempt to talk to you very quickly, about the proposed draft amendments to the private security industry regulations. They were published in the Government Gazette on 28 March and they're open for public comment for a period of 4 weeks, meaning public comment closes on 25 April. These are extremely far-reaching and immediately harmful regulatory proposals that is going to have a direct and meaningful impact on you as a private citizen. It'll affect, in fact, every single stakeholder of the private security industry, which includes all of its clients, all of its suppliers. The backward and forward linkages are extensive. I'm not going to unpack them all here. Also, I apologize in advance for the fact that you have likely seen a lot of good information out there already in the form of articles and videos done by other people. And I might actually retread a lot of ground covered by those guys and girls. Not intentionally, but it's just easier for me to get a flow going and stick to the program here as opposed to try to avoid and cut out what's already been covered. And in any event, I don't know if everyone's already seen those. But if you have seen them, good. Yeah, this might then sound quite familiar. Now, there are numerous debilitating, damaging, and harmful provisions within these proposed regulatory amendments. In fact, I would go so far as to say they threaten to completely destroy the private security industry in South Africa. That employs approximately 580,000 actively registered security officers serving millions of clients. They are a cornerstone of public safety and, in fact, also national security in South Africa, with the amount of joint operations being performed by private security firms in conjunction with the South African Police Service, as well as so many community safety and security initiatives in partnership with private security firms, that if you had to cut this industry out, we would be in extremely big trouble. Now, getting your comments in, by the way, before the 25th, the email address in the Government Gazette is completely incorrect. The correct email address is regulations@sira.co.za. I'll put that in the comment section below this video. But I also highly recommend that people make use of the free SA public comment campaign. They're a very transparent service. They're free. They make sure your comment doesn't get lost or your input doesn't get lost, and they will track and count it. So they are also, the link to that campaign is also in the description of the video below. So let's actually just dive into where some of the big problems are. And there are many, right? And let's start with sub-regulation 13A1, paragraphs J and K, which are extremely broad. Essentially they say that any security firm which is simply under investigation for an alleged or suspected offense or violation will be prohibited from issuing firearms to any of its armed officers. Therefore, a security firm can effectively be prevented from performing its tasks and duties and fulfilling its contractual obligations to its clients without being officially suspended. It merely has to have allegations against it, whether those allegations are frivolous, have zero foundation, or be outright malicious, doesn't matter. As long as those allegations lead to an investigation, it means that the firm can effectively be shut down on that basis. This will result in termination of contracts and firms going out of business, service provision becoming much more expensive and less reliable, and just generally have an extensive and extreme negative impact on the industry. Paragraph Q of the same sub-regulation effectively prohibits security officers from possessing firearms in public locations unless all the extensive requirements under paragraph U are complied with. Essentially what this means is security officers can't have firearms in malls, shopping centers, restaurants, libraries, churches, public parks, wherever. In fact, pretty much almost all public spaces, unless a whole bunch of documentation and risk assessments and requests are submitted to the regulatory authority, who can then decide to approve or deny whether those meet its vague and unspecified expectations. So this process is severely open to abuse, and it will essentially mean that any security guard that transits through, stands off, or patrols through these public spaces won't be able to be armed, which means that whether or not you can even have armed response in your neighborhood now becomes an open question, and my answer to that is leaning towards no. This would effectively ban armed response unless the armed response company can satisfy the regulator that it needs to carry guns in these public locations. It definitely affects other armed response clients, not just in neighborhoods. We're talking here about retail centers, malls, manufacturing facilities, retail facilities, warehouses, where the public might be, churches, restaurants, hospitals, this sort of stuff. So no armed response for hospitals, right? It makes complete sense. Moving on to paragraph S, which is equally vague and ill-defined, where it says that armed response officers should be issued no more than a reasonable quantity of ammunition. Now, the question here being, what is a reasonable quantity of ammunition? How is this defined and quantified? And what are the underlying assumptions and their foundations? Now, when you talk about reasonable quantities of ammunition, the South African private security industry operate in a very wide variety of operational contexts. Let's take a rural mine security tactical response team, for example, that has to go up against Zamas and other high-level threats like that. It would probably be very rational for them to, at a minimum, issue every one of their tactical team members with at least 60 to 90 rounds of ammunition. 90 rounds of ammunition means they only have 2 spare magazines for their rifles, right? That's not a lot of ammo. Whereas a urban or suburban armed response patroller with 2 spare magazines for their handgun would probably be sitting on a total of 45 rounds of ammunition. Is that reasonable? Is that unreasonable? We don't know. The regulator doesn't tell us. So we don't know how reasonable will be judged, and we don't know what can be considered reasonable, and it's therefore open to extremely subjective interpretation, and including such requirements in a regulation creates unnecessary and unwanted uncertainty and risk. Okay. Moving on to sub-regulation 13A8, paragraph F, which stipulates compulsory annual medical, psychometric, and psychiatric evaluations of all armed security officers at the cost of their employers. Now, this sounds pretty good on paper, right? It sounds like an aviation medical exam. The only problem here is that no guidance regarding who is certified to carry out these examinations is provided, what criteria must be satisfied, and how one is supposed to assess the mental emotional condition of armed security officers. So they create a requirement, a compulsory requirement, and then provide zero guidance regarding how to satisfy the requirement. Yeah, that's not good in and of itself. Moving on, sub-regulation 13A, 12 and 13. This is a banger. Place potentially significant restrictions on the issue and use of semi-automatic rifles by private security firms. So at this point in time, the only firms or only functions that are allowed access to semi-auto rifle are high-value goods in transit, like cash in transit, the guarding of key infrastructure points, like national key points, and anti-poaching. Now, you can under sub-regulation 13 apply to the authority for exemption and say, well, I run tactical teams and tactical intervention units, I need semi-automatic rifles too. And in theory, you could get that approved. But the fact is that as things stand now, if you run tactical intervention teams or high-risk units, you are locked out of access to semi-automatic rifles. So this means none of those teams or units will be able to function to the level of effectiveness, or required level of effectiveness. In fact, some people have told me that their level of effectiveness will be reduced by 90%, in which case you can't run a team. The implications of this are potentially highly significant. So I'll just read what I wrote here. Security officers can protect high-value goods in transit with semi-automatic rifles, but cannot protect those same goods in their warehouses or depots. Mine security, both in-house and contracted, cannot protect their facilities, often targeted by Zamas and other armed and dangerous criminal groups or assets. Tactical intervention teams and high-risk units protecting retail complexes, shopping centers, industrial parks, and corporate offices will be similarly rendered toothless and ineffective, and anti-hijacking units will be forced to confront dangerous hijacking syndicates while armed only with handguns. And bear in mind, right, we're not just talking here about intermediate or full-power rifle calibers here. We're talking about things that are pistol caliber carbines, shooting 9mm. So everything would be regulated beyond the access of firms that really need it. Now, what makes this furthermore interesting is the fact that if you are a private security firm and you have serial registration and SAPS accreditation to possess Section 20 firearms, you apply for a Section 20 license under the Firearms Control Act for business purposes, as in you need this firearm to conduct certain tasks and fulfill certain purposes and obligations as part of your security business. And you convince the registrar that there is a legitimate need for you for these guns, and you're issued licenses by the SAPS for them. Holding those licenses grant you certain rights and privileges with regards to that you can exercise as the license holder, including issuing them to your personnel for the conduct of those tasks necessary for conducting your business. This now directly conflicts with the regulatory authorities' proposed regulations. So you have two pieces of legislation contradicting and conflicting with each other and clashing with each other regarding what rights and privileges can you as a Section 20 license holder now exercise, right? So that's already messy. Moving on from there, sub-regulation 13A16. This is a fun one. Requires that all security firms who possess firearms must install a tracking device in every firearm they possess to track the possession and use of such firearms. It does not specify whether this is some sort of electronic tracking device or non-electronic tracking device. I assume it's electronic because I'm not aware of any non-electronic tracking device, but neither am I aware of any electronic tracking devices for firearms that fulfill this requirement. So it's an impossible requirement that firms have to fulfill, but they can't because the technology doesn't exist. It also brings into question what is the purpose of these firms keeping the numerous registers that they are required by law and by the PSIRA regulations, including these proposed amendments to keep, and appointing a responsible person. This is becoming rather clear to me. What PSIRA is doing here is it's infringing on the SAPS, who are the ultimate custodians of the Firearm Control Act and gun control in South Africa and the issuing of licenses. And that PSIRA is trying to start regulating firearms, which is, as far as I'm aware, not part of their mandate, not what they're supposed to be doing, and is severe regulatory overreach. And that's also why we're seeing this kind of unworkable nonsense. But it gets worse. Sub-regulation 13B17 prohibits private security firms from using several so-called prohibited weapons. This includes tear gas, which I'm not aware that private security firms are using anyway, rubber bullets, water cannons, and tasers. Tasers specifically. Now, bear in mind, a taser is a specific brand of conductive energy device, primarily used to incapacitate people. So they're not referring to conductive energy devices. They're referring specifically to tasers, which is a brand name, which again indicates to me the poor quality of drafting and work put in here. Now, there is, of course, a caveat that firms can access these prohibited weapons if they satisfy, similar to satisfying the regulatory authority with their with regards to their security officers carrying guns in public spaces. You'd have to submit full risk assessments and all sorts of paperwork to be allowed access to these prohibited weapons. And I believe you have to let them know 7 days in advance before you intend to use them. Now, bear in mind, these devices are all less lethal alternatives to lethal force. They're extensively used in crowd management, crowd control, and in response to violent riots, public violence, and violent strike action, which I'm not aware comes with a 7-day pre-warning period. So effectively, this would pull the teeth from private security responding to those threats, meaning they can't protect the assets, facilities, businesses, neighborhoods, or people that they are contractually obligated to protect, which would again be yet another one of numerous death knells for the industry contained within these proposals. Now, I'm just going to read to you my conclusion on this, and this should tie off this discussion hopefully adequately. These aforementioned examples do not constitute the full amount of flawed, problematic, vague, and outright unworkable provisions contained within these proposed regulatory amendments. There is a myriad of other harmful details contained within, such as handcuffs being classified as weapons and requiring registration with the authority. Yes, you have to register as a security firm every handcuff that you own with PSIRA. How you're supposed to do that, I don't know, nor do they, I don't think. In short, these amendments represent significant regulatory overreach, irrational micromanagement, and extreme administrative burdening of an industry already heavily regulated. Should they be passed, they would represent a significant threat to the continued existence of the private security industry in South Africa. If these amendments aim to tighten control over the private security industry, to root out rogue and criminal players, which we all agree is a good thing, to root these guys out, they're taking the wrong path. Most would agree that purging harmful entities is a vital task for the regulatory authority. I agree with myself. But this can be achieved by enforcing existing laws, not piling on new burdens. Criminal groups thrive by exploiting corruption and inefficiency in state bodies like the SAPS and like PSIRA, operating as sham security firms. The rational fix is to investigate, prosecute, and convict these bad actors, not to saddle a critical industry with costly, crippling restrictions that punish legitimate players and weaken their ability to serve the public and the state. We have to ask why the taxi mafia security firms, why the criminal security firms, why the gang security firms are not investigated and shut down, and the people involved, they're prosecuted and locked up. Why is that not happening? All the laws allowing it exist, all the facilities making it possible, and the capabilities to do so exist. It's just not being done. Yet we're seeing industry destroying regulatory amendments being proposed. By pushing these changes, the regulator risks harming the very industry it is meant to protect, as well as the industry that pays its bills. PSIRA makes a killing annually out of the fees it charges members of the private security industry, and yet it is actively trying to kill and dismantle that industry, along with its clients, employees, and the broader economy. If enacted, they will leave us with a less safe, less secure society. So, important call to action here. Get your comments in before the 25th of April. Send them to regulations@sira.co.za, as well as please do make use of the free essay link in the comment section below and get those comments in. We're running out of time. There's good momentum behind this. I'll do my level best to keep you updated as things carry on developing. Take care. See you soon.